purpose of today's conference is to put together a number of experts in competition law and competition economics to discuss sanctions. I think sanctions are essential to any body of law. If you don't have sanctions, you don't have law. Now the question, of course, is which kind of sanctions? So this conference is about thinking about what are the right set of sanctions. Should we keep the existing system in the European Union, or should we try something else?
The system is not very effective these days. We have very high fines of up to 1 billion euros against corporate groups. But the Commission does not look at the efforts undertaken by group parent companies to prevent their subsidiaries from infringement. This means the Commission will not consider effective compliance programs as a mitigating or exculpating circumstance.
I think sanctions are important for companies. But the problem with ever-rising fines is that in the end it's shareholders and possibly workers who are suffering from that, and not the people who are really entering into cartels and doing bad things. The companies, corporations are the weeping boys, but it doesn't necessarily mean that after suffering the problem would be over, because individuals having participated in the infringement may not be deterred by their own companies being heavily fined.
The only sanctions we can impose are fines for the moment. Whether that is sufficient or not is hard to judge, and that's a kind of counterfactual. If without those fines, how would the competition in Europe look like? Or if we impose higher fines or lower fines, so the counterfactual is a bit difficult to judge. Imposing criminal sanctions, what the effect of that would be, well, we have seen a number of member states where they have tried criminal sanctions, and we have seen that that is increasing the thresholds in order to sanction, and that may lead paradoxically to less sanctioning. The question is whether in terms of deterrence, which everybody agrees should be the objective of sanctions, whether that is a good thing.
I think the absence of any sanctions to be taken against individuals under EU law leaves a gap that means deterrence is insufficient, and there will be continuing violations. The fines levied against companies can induce them to implement compliance programs and to do what they can to prevent employees from engaging in price fixing and collusive tendering and other serious violations. Simply putting it in the company's interest to prevent such violations doesn't make it possible to prevent them all, because it may still be in the interest of individual employees.
I think criminal sanctions, and then especially jail sentences, are the most efficient. I guess everybody agrees on that. The empirical evidence that has been gathered points in that direction. But introducing criminal sanctions in a competition law regime is not easy.
If firms cannot observe in real time the behavior of their managers, giving incentives for profit is actually giving an incentive for engaging into illegal conduct. If managers are actually directly targeted and sanctioned for those conducts, that gives firms a tool to incentivize those managers not to engage into, say, price fixing in the first place.
The problem is the Commission does not have those powers to impose sanctions on managers, so we would have two alternative or ways to solve the problem. One would be to change the European legislation and to transfer such powers to the Commission. This is quite problematic. The other way would be to implement national legislation insofar so that the Commission could transfer certain aspects of a case to the national competition authorities, which have the possibility to impose fines, and this at the same time would serve as a strong argument to reduce the corporate fines.
I think that we can stand up in the world of antitrust as a predictable authority which is under full scrutiny by the courts.
Probably there should be a very important institutional change, because the Commission wouldn't be able to deal with competition law infringements on its own. The Commission could become a prosecutor, but the Commission could not decide on fines or any other individual sanction with the present situation. So I think the very first thing would be to find a role for the Commission in which the Commission would be comfortable and would be confident that the policy that it has been developing for many years wouldn't die simply because of the institutional change and the legal change.
I think there's a natural kind of a joint enterprise here between academics and competition authorities, bringing together the kind of scholarly skills of academics with the knowledge and data that competition authorities have. I think would potentially allow us to start getting at why do cartels form when they do? Why do firms come forward for leniency when they do? And the real big question, which is, what's happening to the number of cartels out there? Are we actually reducing the number of cartels? And that would be the only way to determine whether or not these policies are really working.
What makes this conferences a bit special, standing out, is that you have more of a debate between the academia and forces in the bar, which is only to be expected as the conference is organized by 2 universities.
At the moment, the European Commission is only interested in fines on firms. It's made it very clear that it doesn't want to explore sanctions against individuals. But I would argue that really it should use the European competition network to create mechanisms whereby individual sanctions on the national level, such as the criminal offence, can complement cartel enforcement on the community level.
I think the Commission does a job, as it should be expected to do. But every time the Commission, which is, of course, a European institution, does something, it does it through the idea that it does it with political legitimacy. And the only political legitimacy it can rely upon is the scrutiny of the Parliament, for which all legislation is passed must of course go through the committees that is set in place. This is the only area, if you like, body of law which does allow for the Parliament to be excluded and just have a consultation right. I think this has to change. I think we have to push towards a more modern era where Parliament has a far more vigorous role